My name is Tom Bickel on behalf of the Brown Undergraduate Law Review. 10 days ago, for our special guest feature this semester, I had the privilege to be joined by Marci Hamilton. Ms. Hamilton is a Fels Institute of Government professor at the University of Pennsylvania. She's also the founder, CEO, and academic director of Child USA, a 501c3 academic think tank dedicated to preventing child abuse and neglect. Before coming to Penn, Professor Hamilton was a chair of public law at Cardozo School of Law. Furthermore, she was a former Supreme Court clerk for Justice Sandra Day O'Connor in the 1989-1990 term, during which the momentous religious liberty case known as Employment Division v. Smith was argued. Lastly, she's also the author of God vs. the Gavel, The Perils of Extreme Religious Liberty, which discusses related legal issues pertaining to the separation of church and state and challenges the pervasive assumption that all religious conduct deserves constitutional protection. What is sort of like the broadest thesis of that book?
To put it simply, the Constitution is intended to be a constitution for all Americans, not just for certain ones. And it certainly prohibits the imposition of one religious viewpoint on the entire culture. So the question is how do we thread the needle of religious liberty at the same time that we're trying to ensure that there is meaningful separation of church and state? And my proposition is that there's really a very straightforward answer, which is supported by all of the case law, which is that religious organizations and believers should have liberty to practice their religion up until the point they harm someone. So there is no built-in right from the perspective, certainly of James Madison, that religious actors have a right to use their faith to exclude and harm others. And so the book is based on essentially, I was clerking at the United States Supreme Court for Justice O'Connor the year that Employment Division versus Smith was decided. I then litigated at the Supreme Court the Religious Freedom Restoration Act and prevailed. It was held unconstitutional. And I'm the leading legal expert in the country on what happens when religious groups break the law. So child sex abuse is a crime, but not only that, it's a tort. So it's inevitable that in every single one of the sex abuse cases that the churches raise their right to free exercise, and that they argue that they don't have to cooperate with the legal system because of their religious beliefs. So that's how religious liberty enters these cases. It's from the defense side, right, and the ones who covered up the abuse.
Right. So it's essentially religious groups claiming an exemption from neutral, generally applicable laws, right? That would you call those secular laws? Is that how you like to phrase it? How do you like to phrase just the broad laws?
No, they're not secular or religious. They are governmental, neutral laws of general applicability. But what the religious organizations have been doing since this scandal really hit, which was first in the 80s and then really hit the public in 2002 with a Spotlight report out of Boston, the religious organizations have concocted something the Supreme Court has never, ever embraced, and what they call church autonomy. So essentially, they're arguing that they get to live in the United States and act in a lawless manner while everybody else is controlled by the law. And so for me, as a Presbyterian married to a devout Catholic, that is the literal opposite of what the Supreme Court has created, which was a doctrine of ordered liberty, not chaos. But it's also, at the time of the framing, I've written about this rather extensively. It was common in every state constitution and also in the culture to talk about, while you have religious liberty, you do not have a right to licentiousness. And by that, they meant all manner of issues, including marriage and whether or not you
probably get divorced. Right. Polygamy is a big example of that.
Yeah, sex assault. So So the framers saw a universe, and the states saw a universe where order and safety was an automatic limit on religious liberty. And our culture has forgotten that, in part because we have law professors that have led us astray. And so there are two camps. It's Doug Laycock and Michael McConnell, both of whom I know very well, but I do not agree with their work at all. And me and Leslie Griffin, a professor out at UNLV. This is a lively battle, and frankly, the public is getting our side of it now. We live in this Pollyanna world where, oh, well, if a religious actor does it, it won't hurt anybody. In fact, it's good for us. And then it turns out they covered up sex abuse, and they marginalize LGBTQ, and they trap unwitting believers in arbitration agreements over rape, which is the Scientology cases I have.
If I'm understanding it correctly, I'm just trying to phrase it in more casual terms, is that the main concern that you have with these extremist groups sort of abusing the protections that are granted under religious liberty or church autonomy is that a lot of these groups end up using that to subvert law and order, not only subvert law and order, but just, do things that most Americans would agree are just bad things. I mean, just objectively harmful, denigrating things, right? And
well,
how come this doesn't get
actually,
reported is sort of my instinctual reaction is how come more people aren't familiar with this?
well, so I'm not saying that I'm concerned about extremist religious groups, although I am. I'm concerned about every religious group. The issue here is that we have been sold a bill of goods that we should have extreme religious liberty, that we should give rights without responsibility. That's what's wrong with our culture. That's where employment division versus Smith comes in, and it's just plain common sense. So I'm not just talking about the fundamentalist Mormons or the Scientologists or the faith healing groups that let their children die in front of them. I am talking about the Catholic Church, the evangelicals, the Presbyterian Church, my own, the Jews. All of these religious organizations, since the Religious Freedom Restoration Act was passed, have argued in court that they have a constitutional right to lawlessness. The law literally doesn't apply to them. So that's what I'm talking about.
So requesting exemptions from these laws based on their religious affiliation?
No, once the statute, the Religious Freedom Restoration Act was passed, they assert a statute, which is there is a federal version applied to federal law.
Right. And then
there are about half of the states that have adopted this standard.
Yeah.
And so they sue for religious liberty, not under the Constitution, but under the statute.
Oh, I definitely read about about some of the Mormon examples are like fairly obvious with polygamy. The history of polygamy there is deep. What would you say are some of the other extremist groups that more go under the radar but are equally like subverting law and order?
Well, so if people want to really understand this, there's a great Rolling Stone is great on these issues. And so I would look at Rolling Stone's article on the Children of God. It was a sex cult that came out of Berkeley several decades ago and started with the leader first announcing that everyone should have sex with each other. But it then extended to everyone should have sex with children. And so it was a commonplace practice to have sex with 3-year-olds. Wow. And so obviously a lawless group. But I'm much more concerned about the mainstream religious groups that are breaking the law, like the Catholic Church insisting that it doesn't have to deal with LGBTQ in the foster care system. Or
so that's the Fulton County case you're referring to?
That's the Fulton County case. Yeah.
So I'm assuming your position on that is that they ruled incorrectly by allowing the CSS, I think they call it Catholic Social Services, to discriminate against the foster families that are same sex, right?
Well, so I thought that decision was correct, actually, not the result,
Okay.
but the fact that Philadelphia had this complete discretion whether to apply its anti-discrimination law made it a complete discretion on the part of the government with respect to the First Amendment is always a red flag. So that I thought was right. Then Philadelphia went back, as they should have, and got rid of that discretion and basically have a law that says anyone who is going to take city funds, it's not saying that, we're not even talking about the Catholic Church fully funds its own foster referrals.
Right.
What we're talking about is if a foster referral agency takes city funds, when it does that, it may not discriminate.
Right.
So as you can imagine, no one would accept the concept that they would refuse to place in foster care people of color, kids of color. That's just unthinkable. And so now we're in a new universe, and not that new, but we're in a universe where LGBTQ are human beings who have civil rights under the Constitution, and the ability to shut them out based on their sexual orientation is a blemish on the civil rights movement for the humanity of LGBTQ. So I really don't have much sympathy for an organization that insists they get state, local, federal funding to discriminate.
Right.
It's a completely different universe if they're on their own, they're not taking the money, and they just offer themselves out.
Right.
That's not what's going on in this case.
No, I see what you mean. I mean, like phrasing it that way and distinguishing that, if they were left to their own devices and their own funding and their own resources, and for an organization such as or as large as the Catholic Church, like they certainly have the resources to do that. It's not like it's not like some fringe group that might be a different situation, but framing it like that with saying that they can do that on their own dime, but to accept the benefits of public funding, and then to go ahead and use that funding, and so that's where the state entanglement is right there. And
that's the problem.
The funding, and then still discriminating, which doesn't make sense, because as soon as you accept that state funding, you should be adhering to what would that be, a state law or just federal law of anti-discrimination?
All three: local, federal, local, state, and federal. And so what's being argued in a lot of these cases, and this is what annoys me about the media coverage of this issue, because it immediately goes to the hot button issue, LGBTQ versus religion. But that's not what the case is about. If you take the taxpayers' money, then can you give that to an organization to use according to their religious faith? And here's the thing. James Madison was, of course, the primary drafter of the First Amendment. And he said, not one penny ever from the general taxes to support religion. And what he meant was that as a taxpayer, you're paying in to support the entire community, whether it's local, state, or federal. But when you are, and so essentially what's going on here is that religious organizations have increasingly argued for more money from the government. And what they say is they have a right to it. But what James Madison said is once you start taking that money, you are going to become politicized and undermine the fact that lots of people don't believe what you believe.
Right. And I think isn't one of the other justifications, if I'm not mistaken, is that it's that principle of allowing that entanglement not only corrupts and degrades government, but it also corrupts and degrades the religious institutions that are partaking in public funds, right?
I mean, what's fascinating is to watch the changing viewpoint of, in particular, the evangelical movement, because they started, when they first started talking about charitable choice. And so this was the idea that the government would provide funding for religious organizations, because before that there was a rule, you couldn't fund religious activity. And so the presidents in Seriatim have argued and have actually had an Office of Faith-Based, essentially federal funding. And at the very beginning, Jerry Falwell said very publicly they would never take a dollar from the government because it would corrupt the purity of the faith.
Mhm.
Once the money became available, he was first in line. So, the funding from the government, it can be corrupting, but it's especially troubling when it's religious organizations using the money to further their own specific religious proselytization.
Right.
And so now the evangelicals are arguing, along with many conservatives and others, are arguing that the public schools cannot be the sole source of funding from the government for education. We now need to have funding streams equally going to the public schools and to the religious schools. That, I think, is something this current Supreme Court could uphold. And what it means is we're basically ignoring James Madison's warning, who understood the dangers of theocracy. And we're just going forward and giving rights without responsibilities to, and a lot of dollars to religious organizations.
What do you think about Justice Thomas? So the way that Justice Thomas thinks about the Establishment Clause is that he doesn't think it's properly incorporated into the states, right?
Yeah.
So, and he said that several times. Like, this has been a reoccurring thing for him for a while. That
Right.
anytime there's a big religious liberty case, he has a pretty small concurrence or dissent in it that just says, I've explained this before. It's not properly incorporated. The history doesn't properly incorporate this into the state. But however, if it was, here's what my opinion is, if it actually did apply to the state, right? So do you find the idea that it doesn't apply to states plausible at all? Because there are some people that say that, the Establishment Clause was actually only meant for the federal government. That's why certain states, such as Maryland, were tied to a church, right? And then it took like several decades to get rid of those affiliations in the early part of the country. So just wondering how you respond to all that.
Well, first of all, Justice Thomas appears to be very comfortable with 50 state theocracies. Essentially, what he's saying is Maryland could go back to being just Catholic and imposing Catholic views on all of its citizens, and so could every other state, whatever the faith tradition is there. Or actually, more accurately, which are the faiths with most political power.
Right.
It's utterly implausible. And here's the problem. Yes, the First Amendment says Congress, and it was intended just for Congress. But when the 14th Amendment was added, it was pretty clear that the intent was to change these principles. So you could no longer discriminate on race, which had not been banned under the Constitution before that. You could no longer engage in suppression of speech in the state. And what I haven't seen is Justice Thomas saying that the First Amendment can't be incorporated with respect to speech.
Right.
I mean, if he wants to be consistent and he wants to say it was just Congress, he's got to say that the freedom of speech can be restricted by the states at will because it only applies to the federal government. So it's implausible. It is originalism in a straitjacket, and it's important that no other justices are signing on to that.
Right. No, that's sort of how I thought you'd come down on that. I mean, and I think that's totally reasonable. It is interesting to me, just as someone that knows way less about law and these things than you do. It's just interesting to me because I'm relatively green that I don't think it's often sort of acknowledged, Justice Thomas's view on that. I just feel like it doesn't come up that often because, as you just sort of like unpacked, it's a more radical view than comes off at face value, right? I mean, the implications of not incorporating that are enormous. I mean, that would fundamentally transform our country.
Extraordinary.
Yeah,
Yeah, I mean, he has divorced this concept of his concept of originalism, which no one else shares. He's divorced that from the world around him. If the Supreme Court were to today say that the Establishment Clause does not apply to the states, we would have a civil war faster than you ever thought. And the reason for that is that it would empower our religious citizens who have been persuaded, sadly, that they have rights that don't apply to anybody else. And they should be able to force their faith on everyone, not just their families and their shared believers, but on everybody. There are enough of those now. As a result, Professor Doug Laycock and Professor Michael McConnell completely falsifying ordered liberty. And it would be, I do believe it would be a civil war. And I think the only reason we've only had one civil war is because of the separation of church and state.
right. Because that's, like you said, I mean, it might sound extreme to say a civil war, but that's really exactly what the founders were warning against, right? I mean, didn't James Madison talk explicitly about his terms were internal fratricide, right? Like fratricidal
Yes.
division based on religion. I mean, if every state just coalesced into a different religious group, like that looks pretty fratricidal to me, right? I mean,
Oh, it's terrifying. It's
yeah,
because immediately certain members of that state are either non-existent or marginalized. And let's not forget, we have plenty of religious believers who are racists, and they put their faith in God to support their racism. And
right,
so it would be a disaster for women and for LGBTQ and based on race. But I think the ones who would get hurt the most are the children.
right. And so I guess I'll transition now to employment division. But it's something you mentioned already is something Scalia mentions in the actual majority opinion there, as he says, he uses the line from Reynolds versus US about, every citizen would become a law unto themselves, which is exactly what you're describing with, these different carve-outs and special funding for all these groups. What do you think the strongest case against Smith is, and how do you combat that?
Well, probably the case I won at the Supreme Court, Bernie v. Flores, is the strongest case that justifies Smith. The strongest case against Smith, I'm going to be honest with you, there isn't a strong case against Smith.
I could try to give you one right now. I could try.
Yeah, I mean, you knock yourself out, but yeah, I'm all ears.
Exactly. I think what a lot of people say, so this is along the this sort of Amy Coney, right? So Amy Coney Barrett said in her Fulton County decision that, yes, she recognizes issues with Smith, such as what Alito calls, Alito just says that, I'm sure, yeah, I'm sure you have a lot of thoughts on that. So I'll let you talk about that. So Alito says that Smith is just sort of an abomination for religious groups in our country because it prevents them from fully exercising their faith. It's a complete sort of thorn in the side to the rights of free exercise. So that's why he thinks that it, he wrote a 70-page concurrence in Fulton outlining why it needs to be, done away with. And then Amy Coney Barrett wrote that she recognizes some of the problems that he lays out. However, she doesn't see that there's any good replacement for it. And since she doesn't see a good replacement, she says, I guess we'll just keep it. So,
yeah, I mean, what she writes is fascinating for someone who clerked for Justice O'Connor, because she's basically advocating O'Connor's approach, which is that religious liberty standards are context dependent. So if you have a prison case in O'Connor's world, you would defer to the prison authorities on safety and security with respect to religious liberty. If you have a case involving public schools and gender discrimination, right? So what she's saying is that we should go forward and do it on a case-by-case basis.
Right.
Only 3 members of the court took the position of just tossing Smith. And let me explain why I often feel like Alice in Wonderland. So I was clerking at the court with Justice O'Connor when Employment Division versus Smith was decided. No clerk thought that this was a killer case. No one thought it was going to be the most political case coming out of the term. Basically, what the court said, and it was Justice Scalia, what the court said was that looking at all of our cases in the past, we have never blocked off the law from just because someone's religious. And in fact, if you look at all of our cases except Wisconsin v. Yoder, which is the Amish school case,
Yep, I'm familiar.
then what you see is that we are deferential if the law is neutral and generally applicable. But if the law discriminates against a religion or all religion, or if a law is just essentially persecution, now that we're not going to tolerate. So he laid out this universe, and then there's this beautiful political science description at the end, which says what we're saying is not that religious organizations and believers shouldn't have exemptions from the law. We're saying you've got to make your case in a legislature, and you've got to explain why this is good for the public good. And if you succeed in getting the exemption, of course, we've got thousands, then that's legitimate. So the response to Smith was a complete overreaction,
Right.
And a false reaction.
Right.
Yeah, and it was falsifying the history, but it was falsifying the history because the religious entities had been arguing for 30 years that they should not be subjected to the law like everybody else. And the court rejected it. And then, as Justice Scalia will do, he always did the Zeus from the mountaintop approach, right? I'm going to decide this issue for everybody going forward for decades. And he said, look, here's the dividing line. I looked at the cases. This is what's true. So Employment Division versus Smith is not a change.
That's just maintaining the status quo. Right. So I remember that from your article, which is, just reiterating your point, which is that there's a huge disagreement, in your opinion, a bad faith disagreement, right? Because they're completely misconstruing the actual history of these cases, suggesting that it's a huge change. So they're pretending like Smith is a huge anomaly. In reality, it's just maintaining the status quo, right?
Exactly. So if you read Bernie v. Flores, the RFRA case, the court says clearly that Smith was not a new standard, that the Religious Freedom Restoration Act, which is supposed to theoretically restore the former standard, they say that was never the standard. And so the Supreme Court has weighed in that Smith was in fact their doctrine before, it's still their doctrine. So the whole public relations push by religious entities, like groups like Alliance Defending Freedom, but also, the churches and the synagogues. I mean, there's been this false narrative. So what is the result of now doing what they asked for? They said, okay, well, we want hyper religious liberty. Give us this statute. And it was declared unconstitutional in my case. And then they went right back to Congress and said, give it to us again. And so now we have the Religious Freedom Restoration Act as applied to federal law. And what it means is that the vulnerable are at risk. So we have all sorts of arguments at federal law that the anti-discrimination laws don't apply, that land regulation by the federal government doesn't apply if you're a religious entity, and that you can control both land use and every other federal law based on your religion. So what they did is created, in my view, the current extraordinary division in this country between believers who call all the believers on the left secular, which is not true. The vast majority of Americans are believers, and claiming that they're the only ones that have the religious liberty rights and that they should be autonomous from the law. That is a disaster for the United States.
Do you think the groups that are proposing this false history are doing so completely deliberately and deceitfully? Is there any possibility that they're doing that in good faith?
Yeah, so I think there's a mix. We know the people at the top, the sophisticated people, know full well what they're doing, what they're foisting on society. But I'm sure that there are lots of believers, and this is what worries me the most, right? Because at a high level, we can debate with them and show the truth to the public, and that's what you do, right? At high level constitutional law. But it's sold a bill of goods to lots of believers that they have a right to do whatever they believe, and that they have the right to do it regardless of the harm they inflict. And so what it did is it persuaded people in a way that we live in the matrix, that everybody is its own self-contained universe, and you don't have to care about how you interact with the culture. And that's where a lot of the vaccine avoidance has come from this perspective, which is false, that your constitutional rights begin and end with your vision for the world. That's just not what the Constitution says.
So it sort of just goes to say that you do have a responsibility to your fellow citizen. You do have a responsibility to your community. So these harms that you're inflicting in the name of religious liberty, that's a pretty selfish, individualistic attitude to take, and one that's not consistent with what our country is, right?
No, exactly. I mean, one of the things that we know for certain is that, most of the framers were not deeply devoted religious believers. Most of them were deists. Yeah. So they believed in God. I mean, they look like today, right? Believe in God, but don't have a church affiliation. And so it was built into the Constitution. First of all, I think the strongest argument for saying that religion was never intended to be foisted by the government on the people is the United States Constitution never, ever talks about religion, except to say it can't be used as a test for serving in public service. Right. And other people talk about the silliness about how the opening of the Constitution refers to the year of our Lord. I mean, that was a phrase at the time. It's not, that's how they talked about time. Right. But it's not a religious document.
Right. Oh, I see what you mean. How would you say that your experience clerking for Justice Sandra Day O'Connor, how would you say that affected the trajectory of your career?
Oh, it's extraordinary. It permitted me to go into academics directly from the court, which was a blessing both personally and given what I love. So I'd always been in school my whole life. I have a BA and 2 MAs. So I wanted to go back to school. So I was thrilled to be able to be a full professor at Cardozo Law School. But more importantly, it taught me because of the makeup of the court that time. So when I was there, Marshall was still on the court. Brennan was still on the court. And, Brennan's famous for welcoming his clerks each year and saying, I understand your high-minded values and what you want to achieve, but I'm going to tell you what changes the law. It's called the rule of 5. We have to get 5 votes. And Brennan was the guy that would walk around the building and charm people and twist their arms and get their vote. And he would drop out whole pieces of opinions in order to get the vote of Sandra Day O'Connor. So I think that I learned about professionalism, extraordinary professionalism.
Do you think that he was like the biggest personality during your term?
Oh, they were all personalities, I have to tell you. So Justice Blackmun was on the court, who of course had created Roe v. Wade. I loved it because ever since Roe v. Wade had been in writing, you were never allowed to use the word viability in your so you're drafting an opinion for the justice. You can't use viability because that is a term of legal art that's only applicable to the right to abortion. And it was very illuminating, and there were some very pointed exchanges. And abortion was a hot topic that year. We had 3 cases at the beginning of the year, all of which were challenging. So this is 1989. All of the 3 cases were challenging Roe v. Wade. And I was the clerk that got assigned these cases. And interestingly, every single one settled before they ever came to court because both sides were fearful.
And what was like an average sort of day for you? Like,
oh, it's extremely taxing, but so Justice O'Connor always had an exercise clerk because she had an exercise class in the building where the basketball court was that Justice White set up, highest court in the land.
Right.
And so she had a yoga and exercise class, and there was always someone from the chambers, and that was me. So every morning I'd show up at the office, I'd go work out, go back to the chambers, and literally just work all day. But see, we had 130 cases a year decided. The court's down to about 75.
Right.
So I only took 2 days off the entire year. I took Christmas Day and Easter Day. Other than that, I worked every single day of the year.
Wow.
Mostly 9 to 9. My apartment was directly behind the courthouse building. I literally came up out of the basement apartment, walked into the Supreme Court, and went to work.
Were you friendly with the other clerks?
It's very tight knit. I mean, what was interesting at the time, what's really fascinating in terms of the current culture, is that there was a conservative group of law clerks who would secretly meet called the Cabal. And the Cabal would try to drive the cases toward conservative ends. And they actually, like very early on while I was there, I had done an opinion for with Judge Becker in the Third Circuit before I got there. And it was on arbitration, I think. And it was summarily reversed the first week I was clerking. And it was the Cabal that, because for something in that opinion, the conservative Cabal didn't like it. So it was an interesting year because it was the one year that Justice O'Connor invalidated an abortion restriction that had to do with children. And the Cabal would meet, and then they would designate who was going to approach me to talk about Justice O'Connor staying on the conservative side on abortion. And I don't know if the Cabal still meets or not, or if they continue to call themselves this, but that thinking and that way of looking at the universe is precisely what we have in a majority of the court now. So I do think it's fascinating that this agenda-driven group was meeting in the courthouse in 89, 90, and before and after. And now those tactics have really, that's what you're watching on the Supreme Court.
How do you actually end up in that position? Like, is that something you were thinking about for a long time? Like, I hope I could end up being a clerk one day for a Supreme Court justice, or?
Oh, no, I went to law school to be my grandfather. My grandfather was the district attorney of Casper, Wyoming, and and had argued at the Supreme Court for the state of Wyoming. And, so he was this well-known attorney, but he had a great life. And so I thought, wow, that's a really interesting career. I didn't even know you could clerk. So early on, during the first year, they started talking about clerkships, and I started learning about it. And I was like, I don't know. But I was selected as the editor-in-chief of the Law Review. And so, University of Pennsylvania, EIC, people started saying to me, you need to be a clerk. So I interned for a judge the first summer and loved it, and ended up clerking for two of the most wonderful people in my lives, which were Judge Becker and then Justice O'Connor.
And what was like the final like application process of that? Like, how did you, because I'm sure you knew that you were in the mix or on the table, but
Yeah.
what do you think pushed you over the edge to eventually find yourself in that position?
Well, I mean, everybody who clerks at the Supreme Court has some mentor out there. I had law professors that were, really pushing you, but in the end, it's the interview. That's really because lots of really brilliant, talented law students will apply to be at the Supreme Court and they won't get there. It's really in the end, the personal one-on-one, because you're going to be in chambers with this justice for the whole year. And honestly, I knew I wasn't going to clerk because the day I was there was the day before Justice O'Connor was in the hospital for appendicitis. And she looked green and it was pouring rain. I looked like a drowned rat. I literally came home and said to my husband, well, it's going to be so great to clerk for Judge Becker, and then we can, start our lives. And then her chambers called and said, I was selected, and she just had an instinct, and I did too. I just love her.
It was a legitimate surprise to you when you got the call?
Shock, absolute shock. I mean, if it comes out that the person you're interviewing with is an extraordinary pain all day, like you're going to be associated with the pain. But also it was pouring rain. I really did. My suit was so drenched that it was dripping onto her carpet. It was just everything that could go wrong went wrong. But we had a lovely conversation. Yeah. But I was blessed then. I was selected, and then the top student from University of Georgia, top in the history of the school, was selected. And we became dear friends. So I just loved having Ann Dupree there, and lots of the clerks became friends, and we all kind of keep track of each other.
That pretty much wraps it up. It's just, obviously a lot of kids, at places like Brown and Penn, like they're going to be trying to go to the top law schools. And I'm sure some of them want to end up being Supreme Court clerks, which it sounds almost like a pretentious thing to even tell somebody that that's one of your goals, because the statistics are so overwhelmingly against anybody trying to do that. This will be my last question, is just if you were to give advice to one of your students that's trying to end up as a clerk, other than just attending a top law school, and how would you instruct them?
Well, first of all, clerking at the court is like being struck by lightning.
Yeah.
It literally, you can't control it.
Yeah.
I mean, it was funny because one of the guys who was clerking with me or a year ahead of me would often say that he was going to be a US Senator. Life doesn't do what you always intend.
Right.
So nobody should go in with expectations. Expect the worst, hope for the best. But having said that, frankly, your odds of clerking at the court are higher if you kill it at a lesser school than if you go to, say, Harvard, Yale, Stanford, Chicago, Penn. And the reason is because your whole class is amazing, of course, and you're super smart, but it's that rare individual that is the star the professors pick up to push. And so lots of people who, if they had chosen, like my friend Ann, goes to University of Georgia, is the best student in the history of the law school, and that's what sells her. So there are two kinds of clerks in the candidate pool. Right. They're the clerk that is blown away that law school, and so they're going in and saying, we may never have another candidate, this is your find. And then there are the ones from the top schools. One piece of advice I'll give everybody is never apply to only one or two or three justices. They do not tolerate that. If you're going to apply to the Supreme Court, you apply to 9. Yeah. If they find out you're picking and choosing viewpoints, they're like, nope, done.
So if you're a hardcore liberal, should you apply to everybody on the current court right now?
In a heartbeat. The Supreme Court is a lot less political than it's portrayed. They are using stare decisis, all the cases from history, best law library in the country. You want to find out something, you want the history, you want what is going on, they deliver it to your door. And your justices, other than Justice Thomas, want to have 5 votes. So you'll never, ever succeed unless you work collaboratively, and consensus does in fact push people more toward the middle.
Right.
So, I mean, we have a current Supreme Court that I do think will radicalize some elements of our jurisprudence, but because they've got so many of them, 6. But the tradition at the court is that they are very collegial. They're very close. They're friends, no matter their political, background.
Right. It's like Scalia and Ginsburg, right?
That's right.
Yeah.
So both of them would have been offended that you only applied to them and not the other one.
So that concludes our conversation with Professor Hamilton. We're extremely grateful for her time and for her joining us. And we've linked both her contact information as well as links to her recent articles in the video description. Check those out, and thanks for watching.